Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract issues. Today I'm going to talk about how to write a notice of termination of an employment contract. So, in any employment contract, there's going to be a section that specifically deals with how to terminate the agreement. So, an agreement can terminate in, I guess, one of four ways. So, one, if it's a fixed term, so if the contract only lasts a period of time, let's just say it's 2 years, if there's no renewal language, the 2 years ends, it's not renewed, contract's over with. Don't need a notice of termination letter for that. Second way of doing it is if through mutual agreement. So if both parties, for whatever reason, decide it's fine, they both want to move on, they can do it at any point without any notice to the other party. Another way is through breach of contract. And so in that scenario, if one party feels the other party is in breach of contract, there generally will be language that states they have to provide them with written notice of what they're doing wrong, what the breach is. And then usually there would be some kind of cure period. And that just means a period of time for the party that is breaching the agreement to fix it. So normally that would be somewhere between 15 to 30 days. And so as long as they fix whatever the issue is during that period of time, then the other party can't terminate it immediately. And then the last way, and this is where the provider will write the notice of termination letter, is if it's without cause. And so in almost any contract, there's going to be some kind of without cause termination, which means either party can terminate the agreement at any time with a certain amount of notice to the other. Normally somewhere between 30 to 90 days, kind of depending upon industry. Now, in the notice of termination letter, I find most professionals want to put a long treatise on their grievances with the employer and all the reasons why they're going to terminate the agreement and all the problems they've had. That's a bad idea. So all the professional should put in the termination notice is, per the agreement, I'm terminating the contract via without cause termination section. I'm required to give you 60 days notice. My last day of work should be X date. Appreciate the opportunity. That's it. Sign it, send it off. One thing to think about, in the contract, it will state, it should have something called notice or notices. It'll state exactly how to provide notice in this scenario. So if you're required to provide written notice through a termination letter, it's going to state how that notice can be given to the employer. So most of the time, email's not sufficient, certainly not verbally. Fax normally isn't. Usually it's sent registered certified mail, or sometimes overnight or something like that, hand delivered. And then it will list specifically, here is the address you need to send it to. If a provider or a professional doesn't follow the notices section, the employer could state, you have to stay with us, until you give us effective notice. So I've had a couple of times where I've had a professional come to me and say, well, I just told my boss, so I assumed that was the, started the clock on the 30-day period. And then they waited until 30 days and said, hey, you never gave us effective notice. You owe us another 30 days. So make sure you follow that. But it's just, there's no benefit to airing the grievances. Nothing's going to change. If someone's leaving an organization, then just leave. You're not there to fix whatever their issues are. And it's likely they're not going to be fixed anyway if you're at the point where you want to terminate the employment relationship. Keep it short and sweet. I'm giving you notice per the agreement. This is how much notice I'm giving you. This will be my last day of work. Appreciate the opportunity. That's it. That's all you need to do. I know the inclination is, no, I want to put all the reasons why, but there's honestly no benefit to you. Maybe you'll create some bad blood. Who knows, down the road, if management changes, the job suddenly turns into a great opportunity, could circle back around, and you just don't want to cause any friction where it's just not necessary. You don't have to provide justification of why you're deciding to terminate the agreement without cause. It's just simply not necessary. So so that's what should go in a termination letter, short and sweet. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can always reach us through our website, ChelleLaw.com. That's CHELLE law.com. Appreciate you watching the video. Thanks.